Hi, Anita. We're going to start the meeting since we're all here
Thank
a few
you.
minutes early. So I'll call this meeting to order. Does anyone have a disclosure of pecuniary interest? Seeing none, I'll move on to item 3, adoption of the previous minutes. Can I have a mover and a seconder? Moved by Glenn, seconded by Ian, that the minutes dated August 26, 2025 of the Short-Term Rental Committee be adopted as circulated. Are there any questions on those minutes? Seeing none, all in favor of that motion? Motion carries. 4.1, public consultation feedback. So there was quite a long agenda package, which all this information here. Kelly, how do you propose that we go about this? Mark?
So I would suggest you probably go through the feedback forms, like the online forms, so the color coded ones, the green, the blue, and orange, and go through them. And if there's anything that you want to speak about or elaborate on, go ahead. And then we can go through the documents that were submitted, like
Okay.
in there.
So do you, because I'm new at this, do you mean like say, sorry guys, does anybody have any comments about these, or do you think I should scroll through each slide?
I think we can scroll through each slide. It won't take very long,
Okay.
because I don't know how many slides there are, but we can quickly go through because some of them are pretty simple questions. Like the first one is just, do you own property here or in area 1, 2, or 3, or go from there. So, and if committee members have any questions, it'd be a great time to ask. And if they don't, we just keep moving on until we get to the other part of it. How does that sound?
That sounds great. Now, the only caveat I will add is that I hate it when people read it out loud because I can read faster. Presumably, we all have the power to read. So if I say, we're looking at question number 1, which is, do they live in the township? Does anyone have any comments on that first slide, question number 1? How about, that's going to be onerous if I say this every time. I'm going to read out the question, and if you have something to say, jump in. How's that sound? Question number 2, do you own or rent property in ACW? Most of them owned it. Question number 3, do you currently operate or use a short-term rental property? Looks like it was, large percentage was neither. I'm sorry, was the hand up? No, okay. Question 4, were you aware of the township's proposed short-term rental bylaw? Most people were. Question 5, have you reviewed the proposed short-term rental bylaw? Most of them had, which is very handy if you're going to comment on it. Question number 6, the licensing requirements. 60% supported, 32 across. Are you waving? Yes, Mary.
Microphone.
I think just going back to question number 3, you were just speeding through them. I think it was really interesting or good that there was a large percentage of people that didn't operate or own a short-term rental. So there's a lot of interest in the community. I just wanted to comment on that.
Yeah, no, that's a very valid comment. I was quite surprised by that actually. So
Yeah,
yeah,
that was good.
that was good. Okay, we're back up to number, I can go slower, Mary.
Thank you. I'm on paper.
Mary.
Oh, okay. So now we're on, yeah, it's way faster if you can just move your finger a little bit. Question 6, which is licensing requirements. About 60% supported, 32% opposed, 6% had no opinion. I'm often surprised by the no opinions because if I had no opinion, I probably wouldn't fill it out. So good for them. Any comments? Nope. Okay. Occupancy limits. Again, fairly common trend. The support was 67%, opposed, no opinion, similar to the last slide.
Madam Chair.
Oh, yeah, please do just interrupt.
Thank you.
Yeah.
On the occupancy limits, I was surprised in the following comments, the more general comments. I was a little bit surprised that there were a fair amount of people that indicated they thought that children should be included, mainly because of septic. And I know that we spent a fair amount of time discussing that. I just highlight that because I thought it was interesting to note that. And I don't know whether the committee wants to take that under consideration, but and discuss it again. But I just thought there was not an overwhelming majority that said that they thought it, but it was overwhelmingly evident that they indicated children should be included in the occupancy.
Okay, so I'm going to make a suggestion. I'm writing that down, children in occupancy. We're going to, what did Florence used to call it? Parking lot that or whatever. At the end, maybe we'll go through all the comments and we think we should flag. Does that sound reasonable?
Yep.
Okay. So I've got one, parking requirements. Unless it seems to be a very similar percentage on a lot of the slides. So unless it's really wonkily different, I'm assuming that people have similar opinions and I'm just going to say, oh, okay, same as,
Mhm.
is that all right with everyone?
Yep.
Okay. So parking requirements. Okay. Noise regulations, same kind of response. Fines and enforcement. Fairly similar.
Mhm.
Question 11, do you have any suggestions to improve the proposed STR licensing bylaw?
Again, Madam Chair,
Yep.
I'm not sure that it came out in these comments, but the comments that I read further on, I noted that a lot of folks, I don't want to say a lot, there were a number of folks that thought that the OPP and bylaw officer should be used more regularly, which again, I thought was quite interesting, particularly as it relates to this question about do you have any suggestions to improve? I don't know that you would call it improve, but alternatively, I guess, which I made a note that I was, not only that, but I was concerned about sometimes the lack of research that some people maybe hadn't fully realized how much discussion and research that this committee has done on this particular item. Anyway, I just thought I'd point that out. It was reflective of what your question here about suggestions to improve the licensing.
Okay, thank you. Is there any other comments on that one? I thought it was interesting, the bylaw distinguished between high impact commercial rentals and low impact family and friends. And I thought we had kind of tried to touch on that with some of our direction. Do we want to discuss that later? I thought, yeah, okay. Second,
As well, Madam Chair, I put another note too that there were a few, I wouldn't say a number, but a few that suggested minimum stays, say like a 2-night minimum stay that might help alleviate the noise and parties and such that most people complain about. That they wondered if having a longer stay period might help to alleviate that problem.
Okay.
I don't know that I agree with it, but it would be up for discussion maybe.
Yeah,
I thought it
think we
was
should discuss
prevalent.
it again.
I
Yeah,
thought
I
it was
mean,
prevalent. Yeah.
yeah, I think that I know that some of these things we've already discussed, but I think it behooves us if we get the comment to discuss it again and make sure that our opinion remains the same with all the additional information. So sorry, I'm trying to keep track. I'm sure the clerks are too, but what was that one, Anita? I got,
About the minimum stay.
all right, minimum stay. Got it.
Yeah.
Okay, Mike, you have a comment?
Yeah, the approach that I took to the responses, not only to the suggestions made on question 11, but also comments made throughout the survey. And I guess I lumped them all under the heading of public suggestions. And I clearly would have missed some, but I had kind of a broad list of about 10 items that I pulled out,
Oh, super.
if I may. And
Sure.
again, I think Anita has already mentioned some of them, but
So to be clear, we're going to have Mike's going to read them out. If something comes up that's not on your list, we'll add it, and at the end, we'll address your list. Does that sound reasonable? Okay, go ahead.
okay. So the issue of tiered licensing, a business STR versus the casual STR for family and friends. A discount to the fees if you have an STR that is complaint-free for a given period of time. Rather than a one-year license, a multi-year licensing system. Some sort of STR directory, whether it be website or some kind of database identifying locations, contacts, licensing status, demerit point status. Anita had already mentioned the maximum percentage of STRs in a given area. I lumped in with that also the minimum length of stay, for STRs. An escalation clause to the fines system. There was one that mentioned a pilot project or potentially a mandatory review period, for the bylaw. Introduction of some kind of rigor on enforcement issues. Expanding the demerit point period from 1 year to 3. And the fact that a license is not assignable to new owners. That was, I think, a specific email that came in. I thought we had perhaps dealt with that, but it came up to a round number of 10 with that one.
Great. Thank you, Mike. Anyone else do that due diligence as well? Mary? Yep.
I think one of the things that was mentioned several times was also about garbage, and who's responsible for getting rid of the garbage,
Okay.
whether it's the
Mike, can you add it to the bottom of your list since you have the first 10? Okay. So that was great, Mike. Good start. So we're on number 11, question 11. So of these comments that are under this question, are any of them not covered by the 11 comments that Mike has on his piece of paper? The number 15, where it says the 30-minute proximity is not necessary. I thought we had addressed that it didn't have to be the agent or the owner. It could be his agent, right? That somebody had to be. Was that in there? It was. Okay. Okay, that's the one that jumped out at me. Limit the number of STRs if the septic inspection compliance is not fulfilled. It should be immediate shutdown plus increased fine to the owners. I found that one interesting. Because right now, I think the fines, if you don't do your septic, are under review or just reviewed. I mean, if you're running a very prosperous STR from someplace distant, it might be cheaper not to do the septic and just keep renting it. You know what I mean? That's an interesting one to me. If you could add that, Mike, to your, if your septic doesn't pass, you really shouldn't be renting it. It's a valid point, I think. Anyone else have any comments from that section? Okay, number 12, if you oppose or have concerns, please explain. Oh, yeah, sorry, Mike, yep.
Took the same approach. I identified this section as a general block as far as reasons for objecting to the bylaw. Is
Okay,
that
great.
general catch basin for this one? So again, shorter list, but
Would you like to read it?
significant. The fail to distinguish between the business STR and the casual STR. I mean, that was a suggestion as far as identifying that earlier. Another common objection, government and regulatory overreach by implementing this bylaw.
Okay.
3, there was a lack of due diligence / legal review of what's been created here. The issue of failing to deal with malicious complaints, and generally the impossibility of enforcing this bylaw given our current structure.
Okay. Thanks, Mike. I was a little confused by there needs to be more about emergency services and fire and rescue services. Is that specific to a private road? Sorry, it's number 5 and 6. I'm not sure what more we'd include. Ian?
I believe that is related to the private road
Okay,
from the conversation I had.
I'm not sure what more we would put in a bylaw about emergency services. But it's noted, I guess. Any other comments on this section? Sorry, Mary?
I think number 6 is, several times it's been referenced that, short-term rentals are monitored, there's enforcement by Airbnb, and I think it's important to acknowledge that a lot of short-term rentals in ACW are not Airbnb.
Thank you. Anything else on this section, Anita?
Can I just ask Mary, that was my feeling too on the Airbnb. Is there something quantitative that you can offer to back that up, that there's not very many Airbnb rentals?
I think there are,
There's some,
a fair
yeah,
few, but I think, and there's nothing quantitative.
right,
It's just my experience in talking with people is that a lot of people have been doing this forever, or doing it for a
Right.
while, and they might have it posted on a site, but it may not necessarily be Airbnb. And there's no, I think VRBO and Airbnb have some pretty strict regulations and some recourse if
Mhm.
the renter misbehaves, or but I think on those other sites, that's not the case. So
So what I'm hearing you say is that people have sort of a go-to list of renters that they normally have that rent, every year, and they draw on that as their rental base. But also, correct me if I'm wrong, does Airbnb and VRBO, do they take a cut of the rental? Is that how that works?
As a director of St. Joseph's Kingsbridge Community, which owns the Kingsbridge Center and the short-term rental next to it, yes, they do.
Is it
and-
significant?
They take a cut of what they give you, and the complaint process is quite onerous
Mhm.
and difficult to enforce. I don't find that it really has a lot of teeth, especially for the kind of complaints that are more common. Yep, Mary?
there are other sites like Cottages in Canada, and there's
Mhm.
a couple of other ones that don't take a cut, but they charge you an annual fee to
Okay.
post on their sites.
Mhm.
And I also happen to know that when my family comes up, there are local, I don't know, people, realtors, they know who's in the area, and it's not verbal and it's not, but they say we need a cottage and they will find one for you.
Mhm.
And I don't know how strict they are about noise complaints. My sisters are generally not that noisy. I mean, that they get complaint. I think they're noisy, but
I guess
Okay.
that's the advantage of living in a rather small community as opposed to living in a community that has maybe a higher proportion of rentals or seasonal rentals, short-term rentals. It's easier to find a short-term rental because you always know somebody who knows somebody. Does that
Mhm.
sound fair? A
Right,
fair,
exactly.
yeah.
They almost always call me first.
Because you know a lot of people, Jen.
Well, not that I want to sick them on, but anyway, they can't hear this recording. All right, so that was number 11. If you oppose or have concerns, do we feel that we captured all the concerns that were in the short-term feedback section? Okay, so we've gone through the 11 questions. Mark, question as to process. Would we go through the letters and get all the concerns in case they're duplicating what's up top?
I think either or will work. It's up to whatever the committee wants.
Well, I think, Mike, that some of your comments you took out of the letters. I recognized a couple of them, right? Okay, then maybe we'll just keep going through them. Okay, I'm on page 28. Who's this from? No person shall transfer or assign a short-term rental license but I think this is corrected in the next one. Roger had some more comments, which Mike, you captured. Should there be something else in the draft that explicitly states that the license terminates upon a change in ownership of the property? This would be disruptive. Perhaps it might be simpler to extend 3.3.1 by adding without the written permission of the manager. Is that in your comments, Mike?
That was identified as an issue, but I actually didn't get to the point of seeing how we address that in the language of the bylaw.
Okay, but it's in there as an issue. All right. So now,
Can I
yep.
jump in?
Yep.
So does the draft bylaw not, like if it's a 1-year renewal, say the cottage was under John Smith at the beginning of the licensing period, and 1 year, and it gets sold to, John Doe halfway through the season, when the license comes up for renewal, is it not captured then?
I think we should put that question in the parking lot because I think one of the things we're going to address is 1 to 3 years, and that might cover some of that. Mike, did you have a comment on that?
Just on the issue of a license being assignable, I think we're pretty clear on that under 3.3.1. No person shall transfer or assign a short-term rental license. That sounds clear.
So then the new owner would have to reapply if they want to continue that business. That makes sense. Because if you're a really good owner and have been for 10 years and you had no complaints, but then you hand it over and you wouldn't even know that it was a new owner, right? Necessarily. Yep, Mary.
And this may be as clear, I just think about probably many people only own one property that they have as a short-term rental. And so it would be selling the property, not the business.
Right.
So.
Nita, are you satisfied with that answer then?
Yes, I think so. I think that makes total sense. I just wondered if there's some kind of caveat that we put in there that if the property is sold before the license expires, that there's no refund.
I guess we'll deal with that if it comes up.
I guess.
Okay, short-term licensing bylaw review. This is a lengthier letter. I think maybe if we just take a minute to go through the letter, just because it's lengthy, I don't want to read the whole thing, and I'm just making sure that Mike's comments captured it all.
I wasn't sure I understood all the acronyms. I don't know what a BCIN designer is or a HCRA/Terry registered builder is.
I didn't either, but I wasn't sure it was relevant to their comments. Mark.
Yeah, so BCIN designer, so that's someone that would design a house and has the qualifications in the background when they submit their plans for a brand new home. And Tarian, I think, is a company that you register like it's a new home warranty program. I
Okay.
think that's my interpretation of those two things.
So not an architect, but similar?
Sorry, I didn't catch that.
Not an architect, but similar?
Someone that has the power. They could be an architect or a designer or someone that can do drawings up. So.
Okay.
Yep, Mike.
Just to start off with a comment, which I don't believe is accurate. It's his second paragraph in the letter. It said during the committee, we heard that this program was described as a revenue generating mechanism. I don't believe we ever identified it as such. I think we had always said it was to be a revenue neutral. I
was surprised by that as too, because I'm sure I said more than once, it's kind of like the dump. It's supposed to be revenue neutral, but it actually costs us money. So, but we always aim to be revenue neutral, right? So yeah, there's just an imperfect understanding here. If you were not at every meeting for every, so yeah, thanks for pointing that out. Well, I think when they're talking about, the costs and all that, they say in here, during the meeting, they estimated 350 for the application, which is reasonable. However, there is no way to cover the costs, all the required inputs. It
But-
should be revisited after the first year.
But I think we did kind of have a rough budget
Yeah.
on that, did we not? I know it wasn't an accurate budget, but it was accurate enough to be taken seriously.
Yeah, the comments that are in here are actually comments that we made.
Right.
So I'm not sure if they heard them and are echoing them or if they thought about it and are putting them forward, but those were certainly, lower the first year to get better.
And
Um,
the second paragraph after that talks quite about there's basically 6 properties that are causing the offenses, and wouldn't we just continue doing what we're doing and put more effort into the bylaw officer and so on. And it goes back to my initial comments that these these actions that the township has been taking to enforce and to regulate somewhat the offensive STRs that have been going on now for the better part of 5 years haven't been working.
right.
And I guess it was a surprise to me and a little bit concerning that not just this comment, but other comments that said, just beef up your bylaws and just call the police more. And I think we talked at length about that we've been doing that with little to no effect.
Yeah, I think that, again, it's an imperfect understanding. There's an educational key to this. Many of these comments are ones that we've talked about.
Yeah.
And it's good that people are thinking the same things and we have reasons for where we've got to. But yeah, I will say that a lot of times I read that and I'm like, wait, didn't we say that? And then I had to go back and look because of course we had.
Yeah.
But we maybe didn't
And I guess too, to say that if what we've been doing with bylaw officers and policing, if it was working, we would never have struck this committee.
amen to that, sister. So, all right. Examples of irregular behavior. I think we're on that part of it. At least that's where I'm reading. So that's where you guys have to read. And I believe we talked about that and that the bylaw officer does have some leeway for what's known as, I don't know, was it malicious complaints or they're just trying to be a pest or, you always want the person to approach the neighbor first as opposed to going right to the bylaw. But certainly if the same person is making all the complaints, then that's also known too. And the bylaw officer has some leeway in there is what I was told by the clerk and I believe to be true. Okay.
Madam Chair, were you looking for the word frivolous?
Frivolous, that's the word. That's a good word. Thank you, Glenn. There is no registration. They did have recommended good behavior reduction in yearly registration fees. Did you grab that, Mike? You did? Okay, great. Like this letter, although, clearly well thought out, has in excess of, I'm going to guess at 50 rhetorical questions. It's hard to keep up with them. And especially since some of them, I know we talked about it. So as long as we're looking at them, I don't think we have to respond. Who's going to verify this if it's not completed by a professional? How are you going to ensure it's accurate and meet the requirements? I mean, there are different comments about people saying, how do you know if somebody crashed on the couch?
Mhm.
And we talked about how that's not really the problem as long as they didn't run out at 2 a.m. and set off fire alarms and scream at the neighbors, right? Like that's not what we're trying to police. We're trying to police the parties, or at least not police. We're trying to prevent the people who know they're coming and staying the night so that they can party all night or whatever they're doing. I don't know.
Mhm.
So the parking management plan, did you grab anything out of there, Mike?
I think you're ahead of me a little bit.
Oh, sorry.
Can I go back to
can.
the section on it's page 34, I guess. The
Yep.
comment on 1.8, the issue of the complaint. I think I picked that up in my first list as far as how are we recording, legitimate complaints. So we'll come back to that one, I guess. I had a question on his comment about dwelling. The very last sentence in that is that the zoning bylaw 32-2008 recognizes mobile homes as a dwelling.
No,
So,
it doesn't.
Are we in conflict in our bylaw by saying mobile homes are not included or can't be included? Does that create a potential conflict with that other bylaw?
If I
Or
could
does it
make
matter?
If I could make a suggestion, Madam Chair, there might be, when they say recognizes mobile home as a dwelling, I think the term that people use in that industry more often now is manufactured home as opposed to a mobile home. I think when you talk about a trailer or a mobile home, it still has the wheels on it. But when you talk about a manufactured home, it's on a foundation of some sort with no wheels on it. Correct me if I'm wrong on that.
Well, I was just at a municipal agricultural development forum, and Huron County was actually presenting about the additional residences that you can put on, and they were showing pictures of the different kinds, and they called them modular homes.
Modular.
And they showed a picture of one, and it was actually the one on my property. So I'm like, okay, that is a modular home, and I will tell you that it is not on a foundation. There is wheels underneath, like it's permanent there, but I think it was built on a pad or something. There's a pad, but it's not a poured foundation per se. But anyway, yeah, they're called modular homes. So I think by mobile homes, I'm thinking of the kind they're dragging around behind the truck, right? And I guess that's where I'm like, But
Oh,
now,
I just
let me
wonder
correct me.
I wonder if this person maybe has confused the terminology somehow.
Mr. Clerk, or CAO, do you have a comment on that?
Yeah, in the bylaw itself, it says private use of single housing unit does not mean or include a tent, trailer, mobile home, or boat. And I agree with Anita's comments that mobile homes are like the ones that they used to produce years ago and probably don't do that anymore, and they're more of a modular unit. So, and again, at the end of the day, when we put this in place, if we have problems with that, we'll have to maybe change it down the road. Like it's not going to be perfect right off the bat. So there may be a few bugs that need to be corrected as we move forward with this.
Okay, thank you. Mike?
Yeah, just while we're on that page, just to comment on a couple of, as you said, rhetorical questions that he's throwing out there. Do we need to provide rental agreements to guests? I think that's just misreading our definitions, because guest is not the renter. The renter is the person that signs the agreement to rent that STR. And as far as the second last paragraph, are you going to inspect each place before licensing to ensure consistency and accuracy? I think it's not the intent. I think the municipality has the option of, if there's maybe any signs of obvious misrepresentation, but we're not going to inspect. So.
Okay, thank you. Any other comments? So you are on page 34, going down to 35. Are your pages numbered, Mary? Sorry. Oh, they are. Okay. So now we're on page 35.
Just a comment about the number of children, because as Anita said, it had been mentioned several times. And I think that when we talked about it, the example here is 5 couples and an unlimited number of children. I don't think that's going to happen, but if you've got a really big place, that could happen, and it could be hard on the septic system. I don't know. I think
That's on our list to discuss at the end, isn't it?
Okay.
Okay.
Yes.
But yeah, it's coming up again here.
Madam Chair.
Yep.
Again, the point about the septic system being the determining factor as far as how many occupants or guests or renters can be in the STR. I think we did settle on the fact that we would base it on bedrooms times 2 plus 2 to a maximum of 10.
Right.
Because there's such a variation as far as septic systems that could be in different, cottages. Some might have a traditional septic system. Some may only have a holding tank. So it'd be impossible to identify exactly what type of system any particular unit has. So I think we agreed that it would be driven by the number of bedrooms calculation as opposed to anything else.
Yep. Okay, thanks, Mike. Okay, moving on to 36, the parking management plan. So I did get that question about the sizing of a parking spot. Like, where did the number 3 meters times 1.5 meters come from? And then there's a Huron County parking schedule, which I thought was interesting. I noticed it way down there somewhere that uses a larger size. I guess put that in the parking lot. Put parking lot in the parking lot, will you?
Does our current draft bylaw discuss about the ability to continue operating if there is an appeal?
I am unclear.
I
Good
don't
question. We'll write that down, Mike.
Yeah,
Mike's my new secretary over there.
I'm not sure that we discussed that in our meetings.
No, I know we had talked about there needed to be an appeal process and what was it going to be? I'm not sure we ever landed on what it was. Certainly went around a few times.
But then as I recall, the appeals come to the council. Is that correct?
I can't remember.
Mark will verify.
Yeah, appeal committee means a committee established by council of the township for the purpose of hearing and making decisions of the appeals and licensing decisions of the bylaw, including the refusal, suspension, imposition of conditions and short-term license. So it's a committee established by council, not necessarily council, but it could be council, but it could be a committee.
It seems reasonable to me that if there was an appeal submitted and a committee was formed of council, that the committee could determine or council could determine whether or not the short-term rental is able to continue during the appeals process.
Well, I would think it would be much like a court of law, right? You're innocent until proven guilty unless you did something really egregious, that you might be a threat in the near future.
Right.
Sean?
Yeah, item 12.4, I think addresses it. It gives the licensing officer discretion to allow it to continue operation during the appeals process until a decision is rendered by the committee.
Okay, great. Thanks, Sean. Yep, Mike?
I was going to say that the language is that the licensing officer may permit the license to continue. If we want to be, I guess, as you say, considered to be innocent until proven guilty, then it would be the decision of this committee and council whether we change the word may to will.
Well, like I said, I think if you're talking about a noise infraction, sure, but we had a problem at our STR a couple years ago, which was not reported to the township, but it was reported to the police, and there was a big brawl where the OPP came out and took them out of there. And you're kind of like, well, that's kind of a different situation. I mean, it wasn't the STR's fault, but you'd want to say, okay, what steps have you taken so that this doesn't happen again? Like that's something different than you had a party, right? If the OPP were involved and there was charges being laid, then you'd want to say, no, we're going to pause on you until we find out what's going on. That's what I meant about the seriousness of it, right? So I think may, in my mind, covers that. You know, should, sure, but if in the appeal process, you could say, okay, I don't know why you shut me down. I want the appeal process moved up, then, I mean, we could be pretty accommodating on that.
Mhm.
That would be my thought on that.
I concur.
Comments? Concur? Okay.
Mhm.
All right, so we're still on page 36. Review, and I'm under the review, refusal, and revocation of registration. Number 13.1.1, what are the time frames for compliance? Did we hammer that out or not? Sorry, we've had so many conversations, I can't remember if we ever closed the conversations or,
Quite honestly, if you have I guess the way I'm reading that, if you have an infraction and now you want a time frame to correct the infraction,
hasn't the person left?
well, I guess it'd be like, if I got a speeding ticket on Highway 21, I've got time to think about whether or not I really sped or not, you know? I don't really understand somebody has complained about, there's been somebody that has given them an infraction. There is an appeals process.
Mhm.
Compliance, maybe it's on the parking issue, but the draft bylaw states if we're saying it's parking and you want a period of time for compliance on the parking infraction, it doesn't take away from the infraction. You're still fined for it or demerited or whatever the case may be. But and maybe they're asking for additional time to, clean up that parking area or make it in compliance with the bylaw. But I'm not sure that I can find anything else besides that. Um,
And you would think that the parking could be on a case by case basis. If you came and said, I need to do this. Yep, Mark?
I think we're probably reading into that whole paragraph because it'll depend on what the infraction is on and
Yeah.
what the proper specified time frame is because it says compliance with the specified time frame. They're not going to put the time frame in the bylaw because we don't know what the infraction is and it's based on what the infraction is, whether it's a emergency situation has to be done right away or if they need to take time to do it. So I think that'll be different for every infraction.
All right,
Yeah.
thank you for clarifying. The expiry of the period for appealing a fine, is that, I thought there should be an expiry date to appeal. You shouldn't be able to come back 4 years later or something. Do we have that in there? And if not, we can talk about talk it up. We can put it in the parking lot.
They've just cut and paste what it says right in here. That's the exact same wording it says in here. The
Okay.
expiry of the period of appealing a fine imposed pursuant to Part 1 or Part 3 of the Provincial Offences Act. Again, the same thing that I said earlier. It's based on whatever the time frame is. I don't think you can just paint everything with the same brush. So
Okay, thank you. Okay, moving on to demerits. And this spans page 36 and 37. I think where it says, how will we know the complaints are against renters and not owner occupants? The owner occupant is responsible for the renters in an STR, correct? So it really doesn't matter who the complaint's against. They're responsible for it and they can take a deposit to pay the fines or whatever it is, right? Yep.
I think he's talking about the example that he put in earlier about his noise bylaw or problem when he was using his own cottage.
Oh, okay, okay.
To me, like whatever we do here is probably going to apply to anybody else that has a cottage because I know in our association, a lot of people, their nephews or friends are like sisters and brothers and kids are there.
Mm-hmm.
So if there's a noise bylaw, they're not going to call just on the STRs. They're going to
Right.
call on everybody. So
Right.
Mhm.
Okay. 16.1.4, are all these documents to be kept on site? I don't think so. Aren't we registering them at the township?
So again, I think they're reading into things way too much because it says that's the inspection. The manager or the officer may, at any reasonable time, inspect any goods, equipment, books, records, or documents used to be used at the owner, tenant, application, responsible person under this bylaw. Doesn't mean like right there and then, like they may or may not have it at the cottage, they may have it at their house, but I think within a reasonable time, inspect these documents
Mhm.
and advise them ahead of time that we're going to want to take a look at these things. So.
Okay.
While
Any
we're on that list of examples, it's come up and it came up a few times that on a noise infraction, that they're wondering what constitutes a noise. And they're talking about, I'm trying to read it where it is, about, a decibel count or something. I think that's a little frivolous as well, to be honest with you. I don't know that anybody ever carries a machine that can determine a decibel level, but I guess common sense would tell me that if it's bothering more than one neighbor, or even if it's bothering one neighbor is one neighbor too many.
Yeah, I mean, it's a pretty common thing in hotels and everything. It's
Mhm.
11 o'clock. You have to be quiet. And if not, someone's going to come and knock on your door. So
Yeah,
I've heard.
I don't think hotel rooms have decibel counter. None of the ones I've ever stayed in have.
Any comments on the page 37? Uh,
Can I just ask, are septic based on bedrooms as suggested here on number 5? If you have a cottage, is your
Go ahead.
septic tank based on the number of bedrooms?
Go ahead, Mark.
As I understand from the building department, it depends on how many bedrooms you have that determines the size of the septic system.
Right.
So
So by
that goes back then to the question earlier about, with the children using the septic.
so we're basing it on bylaw, which
Yes.
no, not by bedroom, which is basically the septic, because that's
Yeah.
what your septic
Yeah.
inspection
Yeah.
is based on.
Mm-hmm.
Yep, Mark. Oh, Ian has a question.
From my experience just recently talking about septic systems, they ask you how many bedrooms, if you have a washing machine, dishwasher, and that is all calculated into the amount of size of the septic system. So
Okay.
cottages, like most of the cottages are built back in the 60s, 70s. So there is no, I don't think there were a lot of standards back then
Mhm.
to current new standards. So anybody building a new cottage is certainly set at a higher standard than what they were back in the 60s.
Thanks. Yeah, I think we're on page 38. Okay. A lot of these questions, if you listen to the meeting, you'll hear the answer. For example, where did the minimum insurance value come from? We talked about that at length. If I do. Will confess, I didn't understand K indemnity agreement. Mark, did you want to explain that to me if it's important? I don't understand it.
Just let me read it first.
Sure, you do that. Nothing like throwing them under the bus.
maybe someone else can help me here. I just trying to find where these F, G, J, K, L things are in the bylaw itself.
Mark, they would be on the application.
Oh, okay, and I don't have that ahead of me. Okay. But those kind of phrases just mean that, and maybe I look to Mike because Mike was used to be in the insurance business. It just relieves us from any liability from.
Okay, would you agree that it's contradictory or whatever that says? Could you speak to that, Mike?
I don't believe it is contradictory. We're certainly asking that the township be held harmless, for any, I guess, situations that are the responsibility of the STR licensee. Having said that, even though they've provided us with a hold harmless agreement or an indemnity clause, the municipality cannot contract its way out of negligence. So if there was negligence that can be attached to the municipality, ACW is going to still be on the hook.
Mhm.
So it's not unreasonable to ask that if there is an incident that may give rise to a claim, that the township be notified of that, just in case there has been some negligence on behalf of the township.
Okay.
But the indemnity clause there, it's almost like signing one of those waivers that you sometimes do. You can ask for it. It may or may not hold up, depending on what the circumstances of the claim are.
Okay, thank you.
Another question.
Yep, Mary?
Could you give me an example of what that negligence might be?
Where the township is actually negligent. I guess if it can be established that the township was aware that a particular property was in contravention of the building code or fire protection standards or whatever, that then if there was a problem relating to the building code and the township was aware of it and chose to ignore it and still issued the license, then I think that would be deemed negligence on behalf of the township.
Thanks, Mike. You are a good choice to have on this committee. All of you were. When it comes to insurance, he knows what he's talking about. Yeah, I thought that appendix was really interesting, and I guess we've put it in the parking lot for later, all the pictures of the parking. So if everyone's okay, we're going to move to the one from Ken Brinley. Did you pull anything from this one, Mike? Okay. Is everyone okay with saying noted and filed? It seems to be very specific to his private road from the way I was reading it.
We do have other potential STRs that are accessed by a private road, do we not?
I'm sure we do. So is there something on here that,
Is this something different than any other private road that is access to get to cottages with STRs?
well, I mean, like there's comments here that this person doesn't think 2 million is enough and talks about insurance. I think most of, unless I'm mistaken, he's asking, what about if it happens on a private road? That's not our jurisdiction. Am I
Mhm.
correct in saying that, Mark? So a lot of his questions are not relevant to what our responsibilities are. Because he says, what if this happens on the private road? What if we block it on the private road? You know, he's talking about the road specifically, is the way that I'm reading it.
If he's asking about the road, it's not our road, so it has no jurisdiction, but the licensing will still apply to anyone that has a short-term rental within the municipality, whether it's on a private road or open road.
Well, like here's the question, how do these apply to infractions on private rights of way? Like, I'm not sure that there's a short-term rental on top of a private rent of way, right? I'm confused by the question, actually. Does anybody want to clarify it for me? Ian?
I think what he's talking about is that his private road has several short-term rentals down there,
Right?
and the road's not wide enough, and it's not. Some of the septic systems are on the roadway, and the cottages are on the roadway, and it says that people are parked on both sides. There's no way an ambulance can get down through. So I think he's worried about his liability, which I have no idea on.
Go ahead, Mark.
This is a civil matter, so I would leave that.
Okay. So now we're going to private road. I'm not sure. Is page 44 associated? Is that a different one? Is that Ken? Is that part of the civil? I'm confused about what page 44 is here.
It has nothing to do with short-term rental.
Okay. That's why I'm confused. All right. So now we're on to page 45. And the authors of this letter, which are very, it's a well-written letter. I promised that I would address each one, and I will. Exploiting a real crisis. Oh, gosh. Sorry. That's the husband. There's your real crisis. The man knows I'm in a meeting. Sorry. Oh, that's on tape too, isn't it? Hi, Donnie. He doesn't watch it. It's okay. I think that there was no intent to exploit a real crisis and to say that this is to look after long-term housing. It was a result of ongoing complaints for a number of years where we eventually said we have to do something to protect not only our residents who are having issues, but to protect the existing communities that were there, because they're only one bad apple away. The manufactured crisis. I really like the survey methods and and all this. Great background information on this. I'm going to use it in some of my other stuff.
Because because it talked about the survey and this, I also made a note. I think we've all had experience, sort of deciphering and interpreting surveys. I know I have in the different councils and boards that I've sat on. And I'll note that 67 people, for the most part, completed the survey. And when you put that against the population of the township, and maybe that's not a fair comparison, but I don't have another piece of data to go on, but if we have roughly 6,000 residents in ACW, it represents roughly 10% of ACW. When I looked up, what's a good response rate on a survey, and I went to ResearchGate, and ResearchGate indicates that 2% is a good it's a good figure for responses to a survey. I guess it depends on the number of questions. The greater the questions, the less likely you're going to have a high percentage of survey. But a good response can be anywhere between 5 and 30%. So although it's not a high rate of response, I think it does represent the population and interest of ACW. So I'll just put that out there because this manufactured crisis did talk about, the percentage of respondents and their opinions. So I thought it was important for us to ensure that we take that into consideration when we're making all these discussions.
No, and I concur. We've done surveys at Kingsbridge Center before, I know I fill out surveys, but only if they give me a Tim's card at the end of it. I would have said 10% would be an acceptable as, oh, you got a good response on that. So I also think that the most people that respond to surveys like this are the people who are not happy. Because if you're happy with something, why bother? Unless there's, like I said, a Tim's card at the end of it, right? So, I mean, that's the way I look on it. So, but at the end of the day, we have residents who we've tried to support for several years now with police, with bylaws, and there's no going forward, mostly because of absentee ownership. And yeah, it started there, but that doesn't mean it can't be duplicated anywhere where someone buys a long-standing community residence, right? So this is protecting what we have and not leaving anyone behind really that needs our help, because they are our citizens and we are responsible for them. Complaint-driven enforcement can be weaponized. I agree with that. And we did talk to the clerk about that. Yep, Mike, go ahead.
Sorry, before we leave the subject of surveys,
Yep.
when we take a look at the percentages as far as the 67 responses that we received, and again, acknowledging that they might be skewed as far as those that have an axe to grind, but as far as whether they support towards licensing, support of occupancy limits, support of parking requirements, noise regulations, fines and enforcement, the support for those were all north of 65%. I went back and looked at the original survey that we conducted before there was even a draft bylaw on the table when we first started this committee, and we had a great response rate from the community of 747 participants. And at the time, so not all of those 747 would have an axe to grind as far as STRs would be concerned. But even then, we had a 55% positive response as far as STRs being regulated or licensing. So again, I'm sure the margin of error is there, but again, it seems to be in excess of 50% easily.
You are really doing your homework these days. That's really good. And now that you say it, of course, I remember that. But it was a long time ago, it feels like. Yep. Mary, was it a year? It's been a long year. Mary?
I guess one of the things is explaining a real crisis and a manufactured crisis. I don't know, having sat on this committee since its inception, I haven't heard the word crisis, that this is a crisis. It's a concern, and it's a concern for, short-term. It's a concern for me. I'm a short-term rental operator, but it's a concern for the community as a whole. But I don't think we've ever looked at it as a crisis, and so it's of interest to me and a concern for me that someone is perceiving this as a crisis or describing it as a crisis.
Yeah, I think what we're doing is actually proactive, trying to stop it from being a crisis. At least that's the intent we're going in with it. Complaint-driven enforcement can be weaponized. So I did talk to the clerk, Florence, who's not here, and I did say, there are neighbors who like to report everything about their neighbors. And the answer was that the bylaw enforcement officer has some leeway to declare comments frivolous. Mr. Mayor is nodding his head. CAO, is that your impression as well?
No, I agree.
Okay. Then we're going to move on from there. Real problems, but wrong targets. Okay.
Can I just address that first bullet?
Yes, please.
About hiring a bylaw officer to work evenings and weekends when the majority of complaints come in particular, how it relates to quote unquote party houses. And again, it goes to my point earlier in the meeting when I said that folks seem to think that we should explore alternate solutions, such as increased bylaw officer hours and so on. I think when we started out, I believe in the first meeting, and I also recall even before the committee was agreed to by council, that part of the genesis of my work towards bringing this to fruition is that if we hire a bylaw officer to work evenings and weekends, that bylaw officer's pay is coming out of the general tax budget. My taxes, your taxes, everybody's taxes, even those that do not have a short-term rental. And I think when we talked about this, going back to revenue neutral, it's a sort of pay as you play, I think is the way we kind of looked at this, that it's unfair to those that don't have a short-term rental, that should be paying overtime for bylaw officers and OPP calls. Similar to, I guess, to look at how we deal with the water issues and the streetlight issues within the township. It's a sort of a pay as you play. So I just wanted to address that bullet because it circles back to my comments at the beginning of the meeting about alternative methods or amping up the methods that we already have.
All right, thanks, Anita. Were you just taking off your glasses? I thought you were waving your hand at me. Okay. Comment I'd like to make on that, the minimum 1 week stay required or to encourage family vacations. We talked about different rates of stays, but there are so many different kinds of short-term rentals who cater to different kinds. For example, Kingsbridge, we're not near the lake, we're right on the highway, and we get rentals all the time for people coming for weddings. Like we just got 2 more last night for next year's weddings. Like people come, they don't want to be down at the lake. They want to be able to get off the highway, stay for a couple days, go to the wedding and go back to Kitchener or Guelph or wherever they're going. Like that's far more of our clientele, which is not nearly as profitable as the weekend one because you have to clean all the time and it blocks out the week, but we get them all the time because of that's kind of where we're at located. So I think by doing it this way, it makes it fair for everybody, or at least that's our attempt, right?
Right.
Does anyone have any, I'm sad. I don't think the word sad's right. We're creating a narrow, invasive, punitive system without full and proper consideration of the consequences. Well, we've been meeting monthly for a year now. We're trying not to do that. We're trying very hard not to do that. And that's what the commenting period is for. And owner-occupied cottages get away with the very behavior you claim to oppose. I don't claim to oppose it. I do oppose the behavior. And if there's an issue with owner-occupied cottages, that is going to be brought to light by this very process.
Madam Chair, would it not be covered under the regular bylaws if it was an owner-occupied cottage and they were setting off fireworks? And
Yeah,
somebody
I think
complained, is that not covered under the regular bylaws as if it
it
were a
is.
house?
I think that the education piece really needs to happen because I don't think everybody knows that, the fire law. I think we have bylaws that were not enforced for a long period of time, so people aren't even aware that they exist. And as part of this, there will be an education piece where we explain what the bylaws are, and then people are quite free to point out the ones that are not STRs that are also breaking the bylaws. Yep, Ian?
I think unfortunately the bylaws that you do have, like the noise bylaw and the fireworks bylaw, and that, like those are all happening weekends and nights where there's nobody around to go inspect, and the neighbor doesn't want to squeal on their neighbor.
Mm-hmm.
So they might put the complaint in, but they're not going to go face them in a court where they're going to get a $10,000 fine for a noise bylaw, regardless what time of day it is.
And that might be something that we need to address further on. And I think that's a huge problem is people don't want to tell on their neighbors, right? Or whatever. And they're not happy that's happening, but they also don't want to rock the boat per se. So, but that's not what we're talking about today, right? So we're going to parking lot that one. The core of the problems, core of the program. Well, it talks about how we swing back and forth, but I think that is what we are, is debating what the right answer is. Nobody has all the answers, and I think that a robust discussion about the different options and what we could do, and then come back later, month later, and we've thought about it some more. How can this bylaw claim to manage complaints fairly when some complaints' real goal is the elimination of STRs and the return of all properties to owner occupation? Well, if that's the complainant's real goal, that's not going to happen. That's not even, they're dreaming. They've been smoking some of the funny grass, because that's not even feasible, nor should it be a goal, and it's certainly not the goal of this committee. The real target, the goal of this program is to catch repeat offenders. That's not my goal. My goal is to protect the citizens of this municipality and to make it so it doesn't happen, and to give the people who it is happening to some sort of recourse to make it stop.
I would also, Madam Chair, if I
Yep.
might, on page 50, I would also argue the the author's comment that what we proposed simply risks placing one broken system with another. I would argue that I agree that maybe what we've been doing for the last 5 years, we have seen that it isn't working. Do you want to call it broken? Okay, call it broken. It's not working 100%. It's not working optimally. It works for a lot of people, but it doesn't work for some people. So now we're having something, we're replacing it with something else. But what we're replacing it with, a short-term rental licensing bylaw. I would argue that there are many municipalities that are opting for short-term rental licensing bylaw. And you can say it's a trend, but I think it's a trend that is obviously working. If it isn't working, why would other municipalities keep following it, and with success? So I'm not certain that I agree 100% in fact, I know I don't agree 100% with that comment. I feel that this is a reasonable alternative that has had much success in many other municipalities. So why wouldn't we try it?
Well, I think to add on to that, Anita, I've mentioned several times that I think this should be reviewed in a year. We have a system that doesn't work. We're trying to do something that does. We'll know in a year if it works or not, and what needs to be fine-tuned. I'm not going to even guess that we're going to exactly right the first time, but that doesn't mean you shouldn't try something. And we also had a conversation, I'm sure we did, when it said you set the bar so low for what qualifies as noise complaints, yelling, shouting, singing, or conversing loudly. I think we all, or many of us, referenced the phones. You're going to say, okay, this is what I mean when I say he's yelling loudly. He's not, singing Kumbaya around the campfire. He's screaming whatever it is under my window. It's pretty easy to make a point. It's pretty common to use. It's even accepted in courts of law that you show your phone video. So I'm not too worried about the inability to decide what's frivolous and what's an actual infraction. We're on to we're at the bottom of page 51, Mary. Yep.
Can you go to the middle of page 51?
Yep, I am.
Just a note about, the use of an American app to identify potential unlicensed short-term rentals. I think my understanding is that we have decided that we're not going to use that at this
Right.
moment in time.
Yep.
It's the response. It's about the short-term rental people identifying themselves.
Yeah, I think we considered everything, or we tried to think of everything. Okay to move on, Mary? Okay. The stakes. The learn as you go is not sufficient. That's all we have. I forget, now I've skipped something. What page are we on? My thing moved.
52.
51. Thank you, people. I really hope that none of those things happen, but we have to try something. And it's signed respectfully with deep frustration, which I appreciate. There's a lot of frustration over a lot of things, and I appreciate the respectful tone. Does anyone have any comments about that final page?
I'll just say that the person that authored this has contributed greatly and appreciate their comments. And certainly it has given us pause to, review and rethink some of the solutions and areas of the draft bylaw. And thank you very much for submitting it. I think it was well done, well authored, and respectful.
Okay. So at this point, let's go to Mike's list. Mike, would you like to share this part of the meeting? Okay, let's go to the item number 1 on the list. Mike, what have you got?
And again, I guess if we run down the list, it would be just a matter of, are we interested in having a further discussion? In a lot of cases, it will be revisiting some of the items that we discussed at previous meetings.
Yep.
But I think because they were mentioned during the public forum, they are worthy of revisiting.
Okay.
So starting at the top, the issue of tiered licensing, business STRs versus casual STRs for friends and families. Is there any practical way of creating a system where you can have a 2 or 3 tiered system of licensing STRs?
So before we answer that, I'm going to say that after every question you ask, I'm going to ask one of our staff here to say, tell me, where did we land on it? So we can say, what did we actually decide on? Because I know we've had these conversations. Just, I think some of the times I think I know, and some of the times I don't know, and some just so we all are thinking the same thing. So when it came to tiers of licensing, what did we land on there, or did we ever land on anything? I know we discussed it multiple times. Anyone have any memories?
Yeah, if I could make a comment, Madam Chair, I don't think we were in favor of tiered licensing. That was my recollection.
Is there a consensus that we had a consensus? I'm not aware that we had a consensus, actually.
I think it was one of those things that we couldn't determine, and we didn't know if you have a tiered licensing and they say, well, it's just friends and neighbors, or just friends and co-workers that we're going to let use. That's all I have too. They're all friends, and we do it full time. But they're all friends. They've become friends. But that's not fair. That's not the. But we've also got other people in our association, and I know other people doing it. They rent out to co-workers, and their kids come up and they get a nominal fee. It's all cash likely. But again, it's to help pay the taxes and help pay the everything else, the upkeep. So
yeah, that's tough. Like Kingsbridge, I agree. Like we are listed on verbal, but the vast majority of ours contact us directly, and we know who they are, right? And they e-transfer us, and then we don't pay the verbal fee because they didn't find us through verbal. So are they our friends? Yeah, I know the person who's renting 2 weekends next week for the wedding. I'm probably invited to the wedding. You know what I mean? So and I'm going to go to you two to more answer this, because you are, you actually do your college more towards family and friends, right? As opposed to ever listing it like we do occasionally get ones who aren't family and friends. So what is your thoughts on this tiers?
for ourselves, because we do the one cottage full time, I think we should pay the full fee. I don't think we should be given a break on that. But we've got neighbors and other people in our association that I would be very, very surprised if they would register. And I'm not going to squeal on us for sure,
Mhm.
but I think there's going to be more of them. And we do not rent, or we don't advertise any place outside of on our own social media.
Mhm.
And we don't advertise. It's because we're booked 2 years in advance now. So
And Mary, what are your thoughts?
Well, I think it's, there's a difference between renting 10 or 12 weeks of the year and you renting 52 weeks of the year. Now, I think along the lake shore, there's not a lot of rentals, 52 weeks, but 6 months of the year, there's a difference in the rate, but I think it's a reasonable rate and we're prepared to pay it. But I know that some people won't, and they'll want to fly under the radar, even if they're renting all year long, right?
So is there a consensus that we're going to do one rate at the lower fee for the year and then we're going to review this in a year? Does that sound reasonable?
Mhm.
Ian?
I'm certainly in favor of the one price. But for the second year or third year, if there's no complaints, no issues, no time spent by outside um, ACW staff, then it should be reduced.
Valid point. Thoughts on that?
If I may, Madam Chair?
Yes.
I think Ian brings up a good point. To delineate who is friends and who is family, that you wouldn't have to pay the licensing fee is really very difficult. There's a lot of blurred lines, I think. But he makes a good point that if you've been complaint-free for a year, um, that's a piece of data that's easy to fetch, and it's not there's clear lines on that. Yes, you have an infraction. No, you don't have an infraction. As opposed to, well, it's my cousin, but it's not my cousin. You know what I mean? Like, it's my mother's second cousin's husband's, whatever. So it's too hard to delineate friends and family. It's not hard to delineate whether or not you've had a complaint or not.
Okay. Mary?
I think the fee is reasonable. The one fee is reasonable. And if, we'll learn over the next year what'll happen. Yeah, I think that's fine. I think that there will be very few people, most 98% of the people who register will not have infractions,
Mhm.
And well, at least I hope that. And but it's hard when it's a small core. But I think we're looking at protecting the community and being supportive of people in the community. So
Well, the other thing that we don't do, but we're starting to look at Kingsbridge, and they certainly do it in all the other areas that I've been to, you have to give them a deposit up front. And you get an infraction, you don't get your deposit back. So then the owner didn't know maybe that they were going to have some Yahoo come in or somebody got a little carried away, your cousin's nephew's friend who came in, but at least there's the money to cover it. And that's one way to mitigate it, right? And then you're going to get more responsible owners too, if they can, or renters, if they're going to lose money if something happens, right? And you can show a clear, okay, I'm going to take it because this happened. Mike, did you have something to add there?
Just a comment as far as it is a very large spectrum going from the cottage owner that rents his place for 1 week during the summer to family to somebody that is renting it for 26 weeks out of the year. And there's a lot of gray area in between those two to try to decide how you delineate what those tiers are, I think is too challenging, too subjective, and I certainly support if you guys are in support of a relatively modest, $350 fee for the initial licensing, then I certainly am supportive of that. And also, it's actually a good segue as far as after year one, do we come back to the issue of discounts
Okay,
for the
so
fee? But
hold on to that. That's a great first thought, but can I have a show of hands for consensus that it's one tier, $350? Is that what we're agreeing on? Okay. Now, Mike, carry on.
So again, it was already mentioned that, that we should be looking at discount for complaint-free licensees. And also, I think that ties in nicely with potentially having multi-year licensing, which is also something that was recommended by some of the participants in the survey. So, but again, I think both those two issues are something that should be perhaps flagged for a year from now, see how things have progressed.
Okay.
If that would, again, if this committee is going to make a recommendation to council that a bylaw be adopted, that is perhaps a little footnote to that bylaw, that we also recommend that, consideration be given to discounts for the fee a year from now, once we are reevaluating that, as well as the multi-year licensing component.
Is everyone agreeable with this approach, which I think is an excellent one, by the way? Can show of hands if you agree with Mike on that? Yeah,
Madam
personally.
Chair, I like the word review it in a year, because we may choose to lower it. However, I would not want to commit ourselves to that. I think reviewing it would be maybe an appropriate word to use, I would suggest.
Okay, everybody happy with that? And just because you said multiple and it was brought up earlier, but I don't think I flagged it. The authors of one of the letters have, my understanding is 4 cottages on one, it's more of a camp kind of thing or whatever. So are we saying that, is that one property? I don't think there's many like that. Like most STRs are on their own lot or whatever, right? But there may be lots that have more than one STR on it. Like if it's I stayed at one in Thousand Lakes Islands, whatever that is over there, Gananoque. And they had like 4 or 5 little cottages all on the same little property, and you could touch the one next door. Like, I don't know how they do it, but how would we do it in that instance? It's one owner. They are rented separately, but you don't have your own lot. I mean, you wouldn't want to be in the 2 unless you knew the one next to you type deal. Like how are we addressing multiple unit?
If I might comment,
rentals?
Madam Chair.
Yes, please.
I think that one fee for multiple cottages on one lot, since we're initiating this and we're just getting our toes wet on all of this, I think it would be unfair and burdensome if we were to charge a single fee for each dwelling that's on the lot. But I think it is also something that we can talk about at a review in a year from now. I don't know how many of those that we have in the township. I would suspect it's, just a very small fraction. And I would agree with you that probably most cottages are on their own lot that are being used as STRs. I think and this person, what they say, 4 cottages on one lot, that's a great deal of money. And I suspect that they probably live on the property as well. So if there's one cottage that's, as you said, an arm's length away from the other cottage, if there's a noise complaint or something like that, the owners of the dwellings are probably right there, and they can, distinguish any complaints at that point before any officer comes out to issue fines or anything like that. So
do we have
that's
a
my thoughts on
consensus
it, but
that?
I put that out for discussion.
Okay, Ian?
My concern with the 4 cottages or 4 rentals in one property is, what's the septic system? And were these bunkies put up after the septic system was put in? So again, hopefully the septic inspections that are being done now will address that.
So how about if for the first year we say 1, and then it might need to be on a case by case basis but certainly our bedrooms and septic should cover the licensing fee, right? Now, if they want, I don't know, that opens another can of worms. What if each one sleeps 4? Now you're at your maximum occupancy of 10, because now you're at 12, right? I have no idea what these things are like, right?
Madam
So is
Chair,
that then 2? Yep.
may I follow up on Ian's comment?
Yes.
So Ian used the word bunkie, which I think is different than what I'm envisioning in the letter that was submitted to us.
Mm-hmm.
I interpreted the letter that they have one lot with 4 cottages on it, but I also know that there are some cottages that have a bunkie and it's listed as a bunkie.
Mhm.
I think that might be classified differently than each cottage being separate.
Shall we start with 1 per property and then review in a year and see if that actually covers everything that we think needs to be covered? Does that make sense? 1 license per legal property? Does that make sense to everyone? Show of hands if we have a consensus on that. Mike? Yes?
Before we do that,
Yep. Anita?
I just wonder if it begs the question, do we need to define a bunkie in the license, in the draft bylaw?
I thought it was. I might be wrong. I
Because
know we talked about it.
I just don't think that what this person has, it would be considered what
No.
they envision as a bunkie.
No, I don't think so either. Mark?
It does say a habitable room, 1.11 means a room within a dwelling designated to provide living, dining, sleeping, bathroom, or kitchen accommodations for persons. This definition shall not include any private garage, carport, cellar, unheated porch or veranda, unfinished attic, unfinished basement, or any space used for the service and maintenance of dwelling. Maybe that didn't answer it. Sorry.
Thanks for reading it though. Okay.
Sorry, yeah, I'm still looking.
Mary?
I think lots of people have bunkies. And you know, I don't know if I don't know if that's included in the rental or, you know, the short-term rental, but I think a lot of, you know, people just put something up that the kids can sleep in or,
Mm-hmm.
you know, and it's not where you can cook your dinner, or it's where you put the overflow or your, the unky bunky, that's where you want your brother to sleep.
Or your husband.
Yeah.
Sorry, was that out loud? I can, Jennifer. Okay. So anyway, so we have a consensus, 1 license. We'll review it in a year and we'll see if it's an issue. Is that reasonable, Mary?
One of the things that came up at the public meeting was about camps that are doing short-term rentals. Do we include them in this? Camp, no.
Minnesota.
Yes, it's right down my road and I can never remember the name. Is it Menacet or Minnesota? But they, in the summer, and off season when aren't kids there, they rent, the folk vest people were in all those little cabins.
Maybe we could ask for a staff report on this. Let's start with what we're trying to
think-
address and we'll see if
Yeah.
we think that's an issue and we can review it then. Does that make sense to everyone? Show of hands? Yes?
Madam Chair, if I could just ask a comment on that. When you cite Minnesota and that come up at the public meeting, why should they be exempt? Shouldn't we treat everyone the same? Just a question.
Well, they're 1 legal property and they have more than 1 thing on it, right? I think that,
Yeah, it's just an like, I don't think that we have
Mhm.
considered that, but if,
but we should. But I think we should start with this. This covers most people. And then I would ask for a staff report at council, say how many of these do we have and how are they policed and should we be doing it? Does that seem reasonable? Because I don't know enough about them. Because I can't
How does
imagine
that-
we're gonna get noise complaints. Yeah,
How does
Anita?
that come back to the committee, though? And the committee will be making a recommendation to council.
How soon are we making, well, I would say, Mark, help me out here.
Well, to me, it sounds like we're gonna have to have another meeting, I think.
Yeah.
I think if you start treating all these like Camp Kintail and Medicine Tongue and the Presbyterian camp, I think
that's not where we were starting.
no, it's not where we were starting, and no disrespect to any of the committee members, but it just we don't get complaints from those campgrounds either. They're
Mhm.
You
Yeah.
might.
Yeah, but that's not to say, that's right. That's right. So how about, I think that's a different beast though. Right now, we're trying to address the singular ones and then we'll look to see, do we need to go further with this? I think that would be part of the yearly review. Like, do we expand this program to encompass the camps? I don't know. We can review it before then too, Ian.
Do the camps not have like Camp Kintail, like they're a corporation, like
Yeah.
they're set up totally different on different bylaws than what a short-term rental would be. Like
Yeah, I don't know.
they're licensed different, I think, and I'm not too sure where this camp.
You go to
is
Anita
at.
then, Glenn, but if we have this many questions, which I think we do, I think that's why we need some further information rather than questions, which we all have. Yep, Anita?
That's where I was going with Ian. It says, I wonder if those Camp Minnesotong and Presbyterian Camp, if they're not a corporation, which maybe that falls under a different category under the short-term licensing bylaw, if it's a corporation, as opposed to a sole proprietor.
Glenn, you.
yeah, they're all corporations there that I'm aware of. Like those three that we just talked about there. Like I know especially Minnesota or Camp
So-
Kintail. It's a corporation name.
So given that, should we maybe ask staff, direct staff to maybe address that in the bylaw that as if it was a corporation, that the licensing fee is somehow different. Maybe it's increased beyond the suggested $350.
I don't agree with that for a lot of reasons. For example, my farm is incorporated, but it's no different than the farm next to it. We still have one barn and one house. Corporation doesn't mean multiple units. Sean, I'm coming to you next. I'm going to actually let you go first.
I just wonder if the township zoning bylaw addresses campgrounds and regulates their usage. And maybe that's something I know that zoning bylaw obviously doesn't speak to short-term rentals, but if there was a provisions in there for
Yeah.
campgrounds, maybe it's not an item for us to address.
Mike.
And the issue as far as being, whether it's a corporate entity or not, really doesn't matter because I think our bylaw also addresses the fact that the licensee might be a corporation because we asked for documentation to
Right.
establish the fact that they were a corporation. And I agree that there could be a business license that these camps would have and the zoning requirements and so on.
So
And again, our bylaw did not contemplate capturing bed and breakfasts either. So just like we're not going to encompass necessarily the camps.
So do we want this to come back with the staff? Like we could ask new business, can you bring back the information about the campgrounds and are we trying to do their short-term rentals, which they do in the winter? I mean, it's a valid question. Is it one we need answered now or can we look at it in a year? What are people's thoughts? I think at some point we have to look at it. Is it important that we look at it now? Glenn?
Madam Chair, yeah, I'm wondering, are corporations no, that's not correct. Are entities like Minnesotong and Camp Kintail, is that a separate beast from the standpoint if the individuals that rent it and have a complaint about a neighbor, wouldn't that be addressed to Camp Minnesotong as opposed to the municipality? Is it something that's outside of our
Jurisdiction?
Yeah, I'm wondering that. Just a
think
question.
That would come back in a report. I would think I think our intent is to treat everyone the same if they're the same. Are they the same? I don't know.
Now, if we brought back a staff report, I'm a little unsure what we're going to have in the staff report because we don't know all these organizations and how they run
Yeah.
and all that stuff because we don't get into that. As far as I'm concerned, when you go to Camp Kintail, you the busloads of kids come in and they're there for a week and they're having fun and they leave again. And I don't know. I
Mhm.
wonder whether it's a whole big can of worms that,
Yep, Mary?
I'm just bringing it up, well, it's in the notes, but certainly I'm bringing it up because of some concern from the people that live below a camp. And the purpose, the usage has become very different in the past couple of years. And so I think that we should stick with the short-term rentals to begin with, but, it may be something that the municipality will hear about,
Yeah, let's put it in the parking lot and see if we've had any complaints and if it needs to be addressed then. Yep.
Yeah, that's something we could review in a year.
Everyone okay with reviewing that in a year then? Okay. Show of hands, please.
Madam Chair,
Yep.
just, I know some municipalities have different classifications for short-term rental. And I wonder if we could ask staff to come back with a recommendation if we, as a short-term rental committee, agreed that camps, such as the ones that have been mentioned, would be classified differently in the bylaw from the short-term rentals that we've been talking about for the majority of the time.
While I see the merit in your suggestion, I think there might be more merit if we wait for a year or like review it. I think the bylaws it's presenting is encompassing what we've been talking about for a year. And I think we're getting lost a little bit in the weeds, trying to fix everything the first year. And we don't even know if it needs to be fixed. Does that make sense?
I can live with it.
Is that a shrug or a yes or no?
I
Okay.
can live with it. Yeah.
You can live with it?
Yeah.
Okay. Mike, what's your next item? Your microphone, Mike? Mike?
Some kind of STR directory website where there's access to information as far as who is licensed, what the status of their license would be, and any contact information regarding that particular licensee. Yeah, obviously privacy concerns and so on as
Yeah.
well, right? So
I'd be real I mean, that sounds like, well, that'd be fun to know, but I'm not sure it's my business what their status of their application is. If you make a noise complaint and they're renting and they don't have a short-term license, that's gonna show up pretty quickly. I don't think that me as a neighbor needs to know if he filled out his paperwork. I just want him to stop doing whatever he's doing, right? Like, I would have problems with the privacy concerns of that. Does anyone disagree with that? Anita?
Oh, I concur. I think you're going to border on freedom of information.
Okay. Show of hands in. We agree. Okay, next.
two-part question, maximum percentage of STRs in a given area, and also the minimum length of stay issue.
I think that we had talked about the maximum amount in the area and we had decided that that was not really fair because of people had already done it or hadn't done it, or that's my memory that we have discussed this. And does everyone concur that at this point, we don't feel the need to limit? I know they're doing that around Collingwood and places like that, but at this point, we don't feel the need. Is that correct? Show of hands if I think we've had this conversation.
Yeah, I
Glenn?
concur with that. I think we kind of landed on the fact that that's up to commerce, and we should stay out of that. As far as the density and also the length of renting, that's up to the
Yeah,
owners.
I feel like we discussed this and we landed on that. Is everyone in agreement? Consensus that is what we had landed on? Okay, everybody's nodding. You're too lazy to put your hands up anymore, but I see you nodding, Ian. Okay, carry on. Mike?
An escalation clause for the fine schedule or repeat offenders.
I like the idea. I'm not sure if that's necessary in year one. Thoughts on that? Ian?
Let's see if we can collect the fines first before you start escalating it.
That seems pretty reasonable. Everybody, Is
Just a
your hand
comment.
up or that's consensus?
Comment, please.
Comment, yeah.
Again, I think we agreed that we would come back to the issue a year from now as far as discounting complaint-free residences. I think that goes hand in hand with that as far as we'll see what the activity level is like and whether it's makes sense to go ahead with an escalation clause.
Okay, consensus that we agree with Mike? Okay, that carries. Go ahead, Mike.
All of that ties into this. There was a comment about. All of that ties in with the fact that there was a comment about, should we have run a pilot project first, or is there a mandatory review period? I think based on the comments that we had as far as the fees and the escalation clause and multi-year licensing, I think we're in agreement already that there's going to be a review a year from now. So I think that's noted.
Is that it?
That was it on that one.
And what about on the
pilot project?
No, the negative stuff. Didn't you have some negative ones written down too, or did we cover those?
Getting there.
Okay. Any more? Oh, sorry, Sean?
Do we want a motion for the recommendation of a review in a year, or has that already been
Do we
decided?
need it? I have no idea. Do we need that?
We don't need a motion, but I think with Kelly taking the minutes that she'll have that all documented that. And in the bylaw, when we bring back the draft bylaw, I would like to put a paragraph in there that says that it's reviewed annually.
Okay. All right. Mike, carrying on to the more negative aspects of it.
Yeah, just a couple of other items I think that we put in the parking lot. The extending the demerit point period from 1 year to 3 years. Is that something to be reviewed? Or we include that in the 1 year review cycle?
I think should go in relation to whether it's a 1 year license or a 2 year license or a 3 year license. I think that the points could go hand in hand with that.
Whatever the decision is. Yeah. Good idea. Does everyone agree with Ian on that? Okay, show of hands. Mary? Yep. Okay.
The other items we put in the parking lot were issues with garbage, and let's deal with the garbage first, because I think it was stated in the sample code of conduct. It indicated that it was the renter that was to deal with garbage issues. I don't think the bylaw per se mandates who looks after the garbage. It's really up to the relationship between the licensee and whoever is renting the cottage as far as how they deal with garbage.
Mary?
I think that the owner and operator should be responsible for the garbage, because if the tenant just leaves the garbage at the end of the road or doesn't do anything with it, the owner still has to do it, and they're responsible for their property. And I think there was a comment in Mr. Brindley's letter about the every day's garbage day during the summer in ACW, and that's not really the case, but sometimes, and I think it's the owner that should do it.
Mark?
Yeah, I think we're starting to micromanage them too much. I think they will deal with the garbage at their own level. They're the owners. They're dealing with their tenants. Whether the tenant looks after it, the owner looks after it, the owner's ultimately responsible.
Right. Okay, everyone agree with that? Okay. Mike?
I think we've already gone through this as far as the septic issues and how that impacts the number of renters or guests that can be in there. I don't think we can deal with that given the diversity of septic systems across various cottages of different ages. So I don't think there's anything we can do about that. We've settled on bedrooms, so let's stick with that.
Is that it, Mike?
That is it.
So the only one that I didn't hear talked about, and we may have, it's been a long meeting and it's almost over. Can you remind me what we landed on as the children? I know we've talked about, is it children under 10, 12? So many? I can't remember what we decided. Is it 12? Is it in the bylaw?
It's 12. I believe it's 12.
12 and under are
believe so.
not counted?
I believe so.
There was comments about children. Is everyone happy with the bylaw as it reads?
I think we're good with that.
Everyone okay? Okay, and if it's not successful, we'll review it and change it if it's not working. But I think it's a good first stab at it. As far as process goes, we've gone through everything. Wait, there's these papers here. Oops. So, Mark, in essence, the committee has gone through the bylaw, we've gone through the public forum, we've gone through the letters. We've said what we agree with, basically the draft bylaw. What's the process here? Do we need to say something or do something or make a motion, or how does this move forward now?
I think all the items we talked about today, a lot of the things we agreed to leave as they were. However, the changes that we had were all, we'll flag it for a year from now. Let the bylaw carry through and see how it rolls, and review in a year and see what happens. So don't think there was any changes to the bylaw, because a lot of it was, let's just sit here, flagged, multi-year flagged, 1 year flagged, annually. Yeah, most of it was review in a year from now, other than my suggestion that we change the bylaw to add it in a paragraph that we review this on an annual basis. Other than that, I don't think there were any changes to the bylaw itself. So I guess it's up to the committee if they are we concluded our journey here, and if so, maybe consensus from the group here, whether you're happy with the draft bylaw that we have. But I guess you don't have it in your copy in your packages today, but you've had one in the past, other than adding in the review annually. Or is the committee happy with taking this to council like this, or do you want to meet one more time?
Mike?
I just have a question before maybe responding to Mark's. Is there anything that this committee wishes to weigh in on and comment to council as far as the recording mechanism for complaints, our comments on if there are malicious complaints, how we deal with complaints, or at least make a comment that owners that are not STR licensees, but are also in violation of other types of bylaws, that, we're tracking those, or we're going to have a more robust procedure in dealing with them, just as we, consider STR violations. Is that the role of this committee, maybe to make a comment on that?
Yeah, I like the comment, and I think that further to that, I mean, when we review in a year, we're going to have a lot of data, and there may be data on STRs that didn't license, and where are we going with them? Those are future decisions. But I like the idea of a comment. Did you have one carefully crafted?
No. But I think it is something that should be carefully crafted, just as we did our letter, or our intent right at the very beginning of this committee's work.
I agree, it should be carefully crafted. My problem is we're into almost the end of the second hour, and I don't have any carefully crafting left. Does anyone have any carefully crafting left in their noggins?
Well, I was thinking that, again, if this committee is going to meet one more time before a recommendation goes to council, that, putting some meat on the bones of those points, be prepared for the next meeting, and then we do the final wordsmithing at that next meeting.
I actually think that's an excellent suggestion. We're going to go to Anita and then Mark. Anita?
Thank you. I have a few comments. I haven't written them down. I'll just go off the top of my head. I think that the committee has done yeoman's work on putting this draft licensing bylaw, as well as, I think even more than yeoman's work has been the staff that have contributed to this. And I think, I would say 98% we have been in consensus over pretty much every detail of the bylaw, the draft bylaw. I am prepared to make a motion if it would suit the committee to send this forward to council as a draft bylaw with the caveat that there is some review pieces that will need to come back in a year. And the amendment, as Mark suggested in the draft bylaw too, that we add, a review in 1 year. But we specify in the review that we will be talking about issues such as camps, the ones that we identified, and you'll point out ones that maybe I've missed, the camps, the discount for spot free or compliance, the escalation clause, multi-year licensing, minimum length stay. I think that's all the
Yeah.
ones that I put in
Anita?
there for, and also with the $350 suggested fee. And I put that out there as a suggested motion because I'm thinking about working backwards. So if we come back to a meeting in November 25th, I guess it doesn't matter. This won't come to council until December, whatever meeting is in December, the 1st or the 2nd.
Mm-hmm.
And I think the goal of the committee was to have this sent to council before the end of the year. And I'm not sure that we'll have another meeting between December, whatever it is, 4th or 1st or 2nd, and Christmas. And then it goes into January. And I think we were hopeful that the draft bylaw would take effect January 1st. I put that out on the table for discussion, and as I said, I'd be prepared to make that motion that the committee approves the draft bylaw to go to council for approval.
Okay, so thank you for those comments. I'm going to make a comment here. I didn't even raise my hand this time. See how good I'm getting after a whole year? I think everybody here has worked really hard, and some really smart people have done a lot of work, and all I did was chair the meeting somewhat inefficiently, I admit. However, having said that, I think we are very, very close to being done, but I don't feel that we are done. I would like to see Mike's suggestion put in there. I would also like to say when we're going to review in a year that somewhere so that the general public knows this is what we haven't forgotten. We listened, we just haven't made a decision yet. We're going to look at multi-tier, perception is a lot of it. And if people think we had an open session and they didn't listen to this meeting, then they like, well, I suggested multi-tier and they didn't even look at it. Well, we are, but we're looking at it a little later. So I would like that to be part of it. I think if we have a meeting, it'll be the end of November. There'll be a draft bylaw with that final paragraph that I would like to see about the review, along with our carefully crafted statements and some suggestions of what we would be looking for in the review so that council knows too. Council needs to know why we want to review it in a year, right? Because that wasn't part of our original mandate. We send it to council. Unless I'm incorrect, it should be able to make it on to the first meeting. This would be a Tuesday night meeting. It would make it onto the first meeting in December and could be passed in December and implemented in January. Am I correct in that, Mark?
It would have to go to the second meeting in December, because if we're meeting on the 25th of November, that'll be short to get that in and
Okay.
out, but stranger things have happened.
We could do it, or we could bump up the meeting a week if we wanted to make sure it passed in December. Mike?
Not to be difficult.
But you are. Go ahead. And by the way, you have 6 minutes and this meeting's over. And so 2 hours is my max.
What you're proposing, and I still support what is being proposed, but it puts us offside as far as the terms of reference for this committee.
Of course, you looked at the fine print, didn't you?
The
So
mandate for the term of this committee is to end October 25, with
Okay.
the final recommendations submitted to council first meeting in November.
So here's my question to the clerk or the CAO. In council, if our meeting runs longer than we want it to, we can make a special thing and say, okay, we get to go over the meeting 3 hours or whatever. Is that possible in this, or is this it because that was our terms of reference? How could this work, Mark?
So everyone knows what the terms of reference is because Michael just said it, but in the agenda, it does say that this is the final scheduled meeting. Should the committee wish to again, staff suggests that the meeting take place on Tuesday, November 25th. So it's entirely up to the committee here. If you want to meet again one more time, so be it. We don't have to change the terms of reference. The terms of reference is just a roadmap to show us what direction we're going. But if you feel that we need to meet again, we can do so. But if the committee feels that we don't need to meet again, and we bring back the proposed bylaw with some of these changes, and especially that will add a review in 1 year from now, and maybe a staff report to get attached with the draft bylaws saying these are some of the things that they want us to look at in a year from now and summarize and go from there. And then like when we do the report too, we could also share with the committee members too, just to make sure that we haven't missed anything. But
Okay, before I go to you, Anita, next, I'm okay with that so long as we could circulate by email what we think are carefully crafted. You say the word, I don't even have any words left, but I'm happy, and then I could submit that as the chair of the committee with the consensus that we wanted also this added, and it would be part of the staff report or something like that. I do think that your idea has a lot of merit to it, and I wouldn't want to have that opportunity missed. Anita?
I'm okay with having another meeting, but I would suggest that we have the meeting a week prior to the November 25th, whatever date that is, the 18th. That's what I would suggest so that we can have it, in good time for staff to have it on the agenda for December the 2nd. Because I think going back to the terms of reference, although I don't see it in the statement of intent or terms of reference, I believe it was the intention, whether it's written or not, that this draft bylaw was going to go into effect January 1st. And in order to complete that, if another meeting is required, then I think the best suggestion would be to move the meeting up a week.
Mike?
Just to declare my conflict, my involvement in November would only be by email.
Okay. So what I'm hearing as a somewhat consensus, of course, I'm only hearing my own voice, is that we have a few more things to iron out. Ian, stop laughing. We could possibly do a lot of work by email. Trust the staff report is going to have everything in it. Kelly's got the minutes. I'm happy with that. I really want to make sure there's a carefully crafted letter, something from us, which I'm sure is going to happen, which can be done by circulation from email. I'm comfortable with staff doing what they've said. Does everyone else comfortable? And I'm going to go to the members who do not have the long-standing relationship that we do with our staff, because I'm quite comfortable when they say they're going to do something. I know they are. So are we okay with carefully crafting, circulating by email, agreeing by email, sending it to staff to include on this, and then this would be sadly, our last meeting? Ian?
Do you have a date that has to be done by?
To make the first meeting in December, what would the date be, Mark?
yeah, if we're going to bring this bylaw back for consideration, the first meeting of council, we'd have to have that all finalized and completed, like staff. I'm talking staff.
Mhm.
If we don't have another meeting on the 25th, we'd have to have that done by the 26th of November. But I don't see anything onerous here that makes staff to have to do anything dramatic, because we're going to amend this to say that we're going to review it in a year from now. And in the staff report, we'd have a staff report going to council saying the committee met on October, whatever today's date is, and agreed to that they support the bylaw as drafted by adding in the reviewed annually. And these are the items of things that they would like to be reviewed. And I have them all wrote down, and we can go back and listen to the audio as well of some of the things that they're missing. I know Kelly's been taking good notes too. I'm going to meet again, whether it be the 18th or the 25th of November. I really don't know what we're going to talk about, because if we've already agreed to everything here, and then a lot of these things have been delayed to see how it's going to be reviewed annually, I don't know what we'd be talking about.
Okay, so we would be talking about the carefully crafted statement, which I think that Mike is going to come up with and email us all, and we can all comment on it, fine tune it, add to it. And I really think we could accomplish that without another meeting. Yes, Mark?
So my question is, I want to clarify with Mike, is can you just, what I understood from you is it has nothing to do with the short-term rental committee. It has to do with the general citizens of the municipality, whether they're going to abide by all the same rules, like when it comes to fire and noise and all the other things that we have complaints about. Is that what you're saying?
Well, I don't think that we can put a short-term rental bylaw on the table without considering how it interacts with all of with the other bylaws. And again, if there's going to be a bylaw enforcement issue, then it has to cross all ACW bylaws as far as how noise and fireworks and property standards and how all of these things are enforced. So what is the mechanism that is going to be in place that ACW can commit to making sure that enforcement actually has some teeth to it?
Yeah, so right now the bylaws are in place and they apply to everyone in the township now. Like there's no special thing just for short-term rental.
Agreed.
It's the exact bylaws that they apply to everyone, not just short-term rental. They apply to everyone now and will continue. So I'm not sure what the whole point would be. Maybe I'm missing something.
Yep.
Madam Chair, I think one more meeting would be appropriate. And we've got a few little details here that I think we need to have consensus on. When we send this to council, I would like to send it with a bow on it, not with questions that would come back to us. So whether the meeting be on the 18th or the 25th of November, I'm more concerned with getting it as right as we can than getting it quickly. I think one more meeting would be appropriate.
I tend to agree with Glenn. The other thing I just realized, and it's after the 2-hour mark, so hey, you get what you get. I would like to see, and I know we've talked about it, and I have said it often enough, there's an education piece to this, and we were going to talk about how we were going to, and we haven't done that, right? So let's have another meeting, and under new business, I would like to put on that the rollout, the proposed rollout, how we inform people, how we educate, how we get that out there. Let's see how we're doing it so we're informed. We had put that in the parking lot and I think we totally forgot about it. At least I did. Yep.
Madam Chair,
Yep.
I appreciate your concern on that. However, I think if a bylaw is passed, it's not up to a committee and it's not up to council members to roll it out. That is up to staff. So we've identified at this level, and I'm sure it will be identified when it does come to council, that there is an education piece on this. But I don't think that's something that we should be concerned with. That is up to staff. And if we ask staff to come back so that we can approve how they're going to roll it out, that's a different story. But I'm not in the business of micromanaging.
I don't think, and like I said, you get what you get at this point. My interest in having it before this committee is because the people here who own the short-term rentals might know the best way to get that information to the short-term rentals. Like if this was, we're going to talk to farmers, I'd say, well, put it up at the Lucknow Co-op and you should probably go here and there's a big gathering at the seed plate. You know, I don't know if you guys have that kind of community, but that would be my interest in. And if you're just interested in reaching out to Kelly, I mean, I have nothing to add about how to do it, certainly. I thought you might. Okay, we really have to get done here. I'm not sure how to end this. Are we having another meeting or not? If you would like another meeting, raise your hand, please. 1, 2, 3, 2.5, 3, 4. Okay, let's do it. Let's do it on the 18th. Can everyone come on the 18th, except I know you can't, but you will be here in spirit and you will have sent carefully crafted what you think would be appropriate, and then the committee can decide if that's what we'd like to say as well. Okay?
Madam Chair?
Yep.
The 18th is a council meeting. We
Mhm.
could see if it's okay with the committee at that point, if they wanted to bring the meeting up earlier in the day for myself, Evan, yourself, and the mayor, and some of the staff. If it works with the staff's timelines too, that maybe we could make it for 1 o'clock or something like that.
1 o'clock doesn't actually suit me as well as 4:30 does.
Okay, 4:30. I just make it as a
We
suggestion.
milk at 2 o'clock.
For
so-
time efficiencies, that's all. Yeah, but that's okay. 4:30 would be fine.
Is everyone okay with 4:30 on November 18th? And I'm gonna ask Kelly before I put it under new business. Would you like input on ways to reach the people who are going to be impacted by this, the short-term rental committees, or not? Would it be a topic of conversation that you would find merit in or not?
Well, we've reached out to everyone regarding the public consultation, so I think we would follow a similar path.
Okay.
So
I thought a while back that in all the meetings that we've had, there was some kind of package, Kelly, that you created on how we were
Mhm.
going to do this and how it was going to roll out. I thought we already talked about that. And
I think we did.
we're seeing the graphics. Yeah, we've seen all the graphics. I thought we knew that already. So
I wonder, I can't remember anything.
So having said that, like I agree with Anita, like how we roll it out should be
Yep, 100%.
councils just well, staff will tell them, and I think Kelly already shared that. So
Yeah,
I
that's true. You are correct. And I think if anyone who has short-term rentals who we have seen the plan, if there's something else you can add, feel free to reach out to Kelly. That makes sense? Okay. Yes.
so are we
Sorry.
still? Yeah, exactly. So my question to the committee one more time is: are we still needing to meet on the 18th of November?
I
Yes,
honestly don't
because
think
we
we
want-
need to. Honestly,
Well, I think
I will go along, I'll attend, but I don't think we need to. I think
we took a vote that we were going to. Mike has concerns. He'd like to
yes.
send it out to us. We need to have a conversation about it. We'll see the draft and we'll go forward. It's not going to be a 2-hour meeting.
All
Okay.
right.
And
Okay.
then I will thank you all profusely because then I will care. Okay? No, I don't. I really don't. Okay. So the next meeting is going to be Tuesday, November 18th at 4:30 p.m. Okay? Do I have a motion for adjournment? Ian and Sean. Moved by Ian, second by Sean, that the short-term rental committee does now adjourn to meet again on November 18th, 2025 at 4:30 or at the call of the chair. Won't be any earlier. Thank you all for your time.
Good night, everybody. Enjoy the game tonight.